SJC-11700, Rivera versus Commonwealth.
Mr. Wood, good afternoon, and when you're ready, we're ready for you.
Good afternoon, Your Honors. One moment. The Third Circuit has stated that it is a bedrock principle of a hierarchical judiciary that no judge shall hear or determine an appeal from the decision of a case or issue tried by him. In this case, we have a question of first impression in this court. Should an appellate judge be precluded from reviewing a cause in which he was involved as a trial court judge? More precisely, did Justice Spina abuse his discretion in refusing to recuse himself from reviewing the denial of Mr. Rivera's new trial motion, where he had participated as a trial court judge in the Superior Court proceedings of Mr. Rivera's co-defendant, Jose Pacheco, specifically granting his motion to dismiss?
So it doesn't matter what he did as a trial judge, just the very fact that he was the trial judge, that's enough?
I don't think that that would necessarily be the case. I don't think I need to stake out that extreme a position. I do think it would be appropriate to look at the role that he played. For example, I mean, you could imagine an extreme position where he simply was the first session judge when Mr. Pacheco's case was called for a status hearing. I wouldn't suggest that that would be enough. And so I do agree that it's not an absolute rule. There would have to be some sort of, we're now in the world of reviewing this for some substantive significance. But I think that whatever that test is, this case satisfies it because Justice...
Suppose it was just a pure question of law that the judge ruled on.
Well, I think that arguably that's what we have here, Justice Spina. I think the Commonwealth makes a reasonable argument that in this case, Justice Spina, then Judge Spina, was presented with a factual, an uncontested factual record. The Commonwealth and Mr. Pacheco's attorney seemed to agree that on the facts as alleged that Mr. Pacheco, which was consistent with the Commonwealth's theory of prosecution in all of these cases, that Mr. Pacheco had been coerced into participating in this murder. And Judge Spina seemed to accept that factual record, seemed to say, I'm not going to receive any counterfactual evidence, so I'm going to proceed with the assumption that those facts are true, and I'm going to base this on a legal decision and my legal decision is, notwithstanding there's lack of clarity on this in the SJC, that duress is a defense, and I'm going to grant his motion to dismiss. So I think it's fair to say that this was a legal decision. Nevertheless, I think that it was, the way I would put it is that simply because a judge has made a legal decision, that is not grounds to avoid the concern about impartiality and the issue of recusal. So I think here, but I also would back up and say that it's important to note that the only reason there was no factual issue here was because the parties agreed on the factual issue. So I think that he's being presented with an undisputed factual record, which I think is important. I think he's essentially saying, okay, so those are the facts. The Commonwealth and the defense, or Mr. Pacheco, agree that those are the facts, and that's significant to this situation and evaluating his level of bias when he comes to, when Mr. Rivera comes before him. Now, we submit that his refusal to recuse himself was an abuse of discretion because it exposed the judiciary and the judicial process to the appearance of partiality. That is, his impartiality might reasonably be questioned. As the Fourth Circuit has stated, a reasonable person has a reasonable basis to question the impartiality of a judge who sits in a U.S. Court of Appeals to review his own decision as a trial judge. That's Rice v. McKenzie from the Fourth Circuit. So I think that...
I guess the response is that he's not reviewing his own decision. The issue is not whether Mr. Pacheco should be dismissed. The issue is whether or not Mr. Rivera is entitled to a new trial.
Right. I think that that's an important distinction that we're talking about here. He was not the trial judge in Mr. Rivera's case. He was the trial judge in a co-defendant's case. And so first of all, as I think I candidly admit in my brief, I have not been able to find a case that is precisely analogous. The Commonwealth argues that the cases I have found are not apposite. I disagree. I think that the concerns in all of these cases, Rice, Clemens, all of these cases, which generally involve federal court judge who is sitting in habeas or appeal review of habeas, reviewing proceedings from the state court where that judge was directly involved as a state court judge. Those are different because we're talking about the same defendant. My case, we're talking about a co-defendant, but I submit that the same concern applies. I think that there are several reasons that it should apply. One moment.
You know, I hope, Mr. Chauncey, that you can help elucidate how it is that anything that Judge Spina would have known from what he did with respect to Pacheco would have any impact whatsoever on the relief that you were asking for.
I want to make sure I understand the question. I think you're asking, in 1993, when he granted this motion for Mr.
Suppose he
Pacheco,
had perfect recollection of everything that took place.
in 2012, you mean?
In 2012, he had perfect recollection of everything that had taken place in 1993. What import does that have at all for any decision to be made about your client?
I think, okay, so essentially what is the basis?
2012, yes.
What's the basis for a claim that this subjects the judiciary to a challenge to its impartiality?
Right.
Right. I think that the first issue is one of the facts. I think that there is this concern that he has been provided a version of events. This version of events is that Mr. Rivera forced Mr. Pacheco to participate in this murder.
The coercion was by, among others,
Mr. Rivera, my client. That's right. Now he's presented with, and that factual scenario is undisputed by the Commonwealth. So when he's presented with this in the Pacheco case, and only in the Pacheco case, this is presented as the undisputed factual truth. And fast forward to the motion, the gatekeeper petition, not 2012, I'm sorry, I misspoke, 2005. In 2005, which is 22 years later, he is presented with a different version of events, that Mr. Pacheco is lying. And I submit that there's a concern there, that the concern is that, well, he's not going to believe Mr. Rivera because he has already staked out a position that the Commonwealth and Mr. Pacheco's attorneys have provided to him, that Mr. Rivera did, in fact, cause him or coerce him into participating in this murder. That's the first concern. Another concern, I think, which is interesting in this case, which I didn't highlight in my reply, but his legal basis was duress. Now, the state of the law on this was unsettled in 1993. There was no clear law from Massachusetts, although the majority of, I think, jurisdictions did not recognize duress. It was not clarified until 2012 by this court in Commonwealth v. Vasquez. And interestingly, Justice Spina wrote the decision. Now, I'm not suggesting anything about Justice Spina's motives in fact. What I'm simply suggesting is, when you're talking about the appearance of impartiality, and that's what this claim is based on.
2012, when that decision came down from this court, it was to say that there was no duress.
That's right. That's
which is contrary to the way he ruled as a Superior Court judge
in
1993. Yes. And I don't understand what the force of your point is on that.
Well, I'm sorry, I'm not making it then. My point is that when it suggests a level of sympathy with Mr. Pacheco. The reality of this situation, this motion being presented to him, is interests of justice, essentially. Look, this guy testifies against 3 other guys in a murder case and exposes himself to some risk. And he does, by the Commonwealth's view, the right thing. And he stands up to these guys who've threatened him and his family and testifies against them in 3 murder cases. The right thing to do is to give this guy a break and dismiss the murder charges against him. That's the idea his lawyer is presenting. and the idea is here that while the law is unsettled, Judge Spina is swayed by this and swayed by the notion that that the facts are undisputed, that he did in fact he was subject to duress and coercion, and so there's ambiguity. I'm going to lean in favor of Mr. Pacheco and justice and grant his motion to dismiss on the grounds of duress. Fast forward many years later, 2012, he takes a different view, and the idea is that when he's making a neutral a view of the law, this is again just what the public perception might be. He's making a neutral analysis of this question. He determines that the law does not provide for duress, and so there's this question: why did he come to a different conclusion in 1993?
Because the law was different then.
Well, the law was not. The law was unclear then.
Unclear, and that's different.
That's right. That's fair to say. I take the point. What I'm simply saying is that
Superior Court judge, you do what the law seems to be at the time. And I think that what Judge Spina then was saying was that it was also governmental hypocrisy to do otherwise.
that could be. That's certainly. I mean, that certainly could be what he was saying.
That's what he said.
Right. Okay. Then, but the question remains: what is the appearance of? Does this give rise to an appearance of partiality when he comes to a different conclusion years later, and the law is not clear at the time in 1993? It's not that he's following the law; it's that in the absence of clarity, he makes a decision to apparently avoid governmental hypocrisy, or in the face of governmental hypocrisy.
First of all, it's not his decision; it's the decision of this court.
No, I mean in 1993.
All right, but in 2012,
No,
that's
right.
not, well, he made a new decision.
Right.
That's the decision of this
if
court.
I said that, I misspoke, and I recognize that that's absolutely right. That in 2012, this court, speaking through Justice Spina and making presumably taking a view of all of the law, came to one decision, which is different than Judge Spina's decision in 1993. And I think that raises a question that is worth considering in the context of a judge's impartiality, the appearance of the judge's impartiality.
All right, thank you.
Thank you.
Good afternoon. May it please the court. I'm Jane Montori, representing the Commonwealth in this case. This case is before the court on two questions. The first is whether the defendant, Mr. Rivera, demonstrated that his request for recusal was timely. And then the second question is whether or not Justice Spina abused his discretion when he denied the motion for reconsideration. And I think a timeline is important here, particularly as to the first question, which is when does a gatekeeper decision become final? In this case, in 1993, then Judge Spina allowed Mr. Pacheco's motion to dismiss. In 2004, after Mr. Rivera filed a motion for new trial in the Superior Court, which was denied by the trial court judge, and one of the bases of his motions for new trial was the affidavits of Jose Pacheco, which had been executed in 2002 and 2003, where he recanted his trial testimony. Judge Ford, who was the trial judge, who had heard Mr. Pacheco testify at this defendant's trial, as well as the trial of Iran Diaz, another co-defendant, denied the motion for new trial. It then went to Justice Spina as the gatekeeper, and he denied the motion, finding that there was no, it did not meet the test for a gatekeeper provision. And that was in December of 2004. Almost 10 years later, this defendant filed the motion to reconsider and to recuse. And the Commonwealth's position is that was too late.
Well, Judge, but when Justice Spina ruled, he allowed the motion to reconsider and then on the merits denied it. So doesn't that moot out the mootness issue? I mean, because it seems to me at that point, he could have said, I'm not doing this, it's too late, but he didn't. He ruled on the merits, I think, and of the motion to reconsider. And so I would think that before us now is the merits of the recusal, not the merits of the gatekeeper itself, but the merits of the recusal without having to worry about the time.
I would suggest he didn't have jurisdiction 9 years after he had originally denied the gatekeeper petition. And the court's order at the Commonwealth's addendum, page 16, indicates that the timeliness of this was one of the issues to be addressed.
Saying that Justice Spina was without jurisdiction to review this? That any single justice would have been without?
9 years later, yes.
Really?
And I would just point out, there was no motion, separate motion, to accept this.
No, I mean, it's not a question of whether or not the judge could have dismissed it on that ground, but the question is whether or not he could have entertained it.
I would
Saying he doesn't have the jurisdiction to have done it, and that's a pretty startling proposition.
well, because of the time. I don't know if jurisdiction is the right term, but 9 years later, there has to be some finality. And in most cases, a motion to reconsider is considered timely if it's filed within the time brought for a notice of appeal, which in the case of a gatekeeper petition is 1 month. Even a notice of appeal from a final conviction can be extended up to a year under Mass Rule of Appellate Procedure 14. But here, where it's 9 years later,
Did you argue this before Judge Spina? I don't know. Justice Spina?
no, there was no response. The Commonwealth didn't respond. We weren't asked to respond.
So I guess I'm just trying to figure out where in this timeliness issue got raised before him.
It was in our order, was it not?
Yes.
It's
It
only
was in our order
our order to this,
to allow this to go forward.
To this,
yes, but I mean, it
for
wasn't
this-
before
It wasn't
Justice
before
Spina.
Justice Spina, that's all I'm asking.
no, not,
The timeliness issue was not something that he would necessarily have.
right, because there was no, it was mentioned in the motion that the motion was timely, but there was no separate motion to accept that reconsideration motion 9 years, more than 9 years after the time that he had originally denied the gatekeeper petition. So it's, and I recognize that there's no right of appeal for the denial of a gatekeeper petition, and that's usually the yardstick that's used for a motion to reconsider. But on the other hand, there has to be finality in a gatekeeper decision, and I would ask this court to set a reasonable time limit for motions to reconsider gatekeeper decisions. One of the reasons given was that the defendant didn't know until 2005 about Pacheco's motion to dismiss, except that they were together in an institution in 2002 and 2003 when Pacheco executed those affidavits in support of the motion for new trial. So getting to the recusal point, first of all, there was no, Justice Spina had no extrajudicial exposure to this case. He did not even make a credibility determination about Pacheco. The Commonwealth had to agree because Pacheco had testified in 4 or 5 trials of co-defendants that his testimony was truthful. That was the Commonwealth's position. So as a matter of law, and Justice Spina at the hearing on the motion to dismiss discussed how this was a very unusual circumstance, but that in these circumstances, where the Commonwealth could not now say that Pacheco was not to be believed, that under those circumstances that a dismissal was appropriate because of the defense of duress. And the Commonwealth, in its brief, lists a number of cases. Eddington, which is from the Appeals Court of Massachusetts, where a trial judge took the plea of the co-defendant, and the appeals court upheld the conviction and said that he was not required to recuse himself. And other federal courts, and I believe a West Virginia court, where there are various configurations of a judge either presiding over motions of a co-defendant or trials of co-defendants, and not being required to recuse himself. And in this case, certainly, where he had ruled on Pacheco's motion 11 years before he decided Mr. Rivera's gatekeeper petition, I think that time frame also negates any appearance of impropriety on his part. And unless the court has...
Do we look at recusal any differently because the gatekeeper is so final and so unreviewable?
No. I don't think that I think the standards are, as they are set, are pretty flexible. But I don't think because in this circumstance, there might be a circumstance that came before the court that would warrant a different kind of look at this. But in these circumstances, certainly not.
Okay, thank you.
Thank you.